Judicial review. The power of the Supreme Court to declare laws and actions of local, state, or national governments unconstitutional. Supreme Court docket. A schedule of cases to be argued in the court. Brief. A written document that explains one side's position on the case. Majority opinion. Presents the views of the majority of the justices on a case. Concurring opinion. The justice who agrees with the majority decision but has different reasons writes this. Dissenting opinion. Justices who oppose the majority decision issue. Unanimous opinion. All justices vote the same way. Stare decisis. Let the decision stand in Latin. Plessy v. Ferguson. Plessy was a man that was arrested for sitting in a whites-only section on a train in the 1890s, which violated Louisiana's segregation law. He then appealed to the Supreme Court, but he lost. Brown v. Board of Education. Issue: does racial segregation of children in public schools deprive minority children of equal protection? Mapp v. Ohio. Could states violate the Fourth Amendment? Conclusion: Fourth Amendment extends to state laws. Constitutional law. Law that involves the interpretation and application of the U.S. Constitution and state constitutions. Affirmative action. LBJ's executive order designed to correct the effects of past discrimination, requirement by law that positive steps be taken to increase the number of minorities in business, schools, colleges, and labor. Amicus curiae brief. Friend of the court, interest groups may be invited to file legal briefs supporting rejection arguments of the case. Appellate jurisdiction. On appeal from lower courts, Supreme Court is mostly an appellate court. Concurrent jurisdiction. The authority to hear cases is shared by federal and state courts. Precedent. A court decision may serve as an example or justification for a later one. Rule of 4. Requirement that a case can only be heard by the Supreme Court if 4 justices vote to hear the case. Judicial restraint. Philosophy proposing that judges should interpret the Constitution to reflect what the framers intended and what its words literally say. Judicial activism. Philosophy proposing that judges should interpret the Constitution to reflect current conditions and values. Writ of certiorari. Order by the Supreme Court directing a lower court to send up the records of a case for review. Supreme Court. The highest federal court in the United States of America. Writ of Mandamus. A written command made by a higher court to a lower court that a specified thing be done. Unconstitutional. The power of the Supreme Court to decide whether or not a law passed by Congress goes against something written in the Constitution. Court-martial. A military court that tries members of the armed forces accused of violating military laws. Moot question. A question of no practical importance. Judicial review. The power of the Supreme Court to declare laws and actions of local, state, or national governments unconstitutional, established in Marbury v. Madison. Counter-majoritarian difficulty. The argument that judicial review is problematic because it allows unelected judges to overrule the decisions of elected representatives, thus undermining the will of the majority. Judicial activism. A philosophy of judicial decision-making whereby judges allow their personal views about public policy to guide their decisions. Judicial restraint. A philosophy of judicial decision-making whereby judges give significant deference to the decisions made by elected representatives in the legislative and executive branches. Precedent. A decision in a previous court case that is used as the basis for a decision in a similar case. Stare decisis. The decision stands, a rule in deciding cases where judges follow precedent, helps promote consistency and fairness in the legal process. Lower courts must follow precedent set by higher courts. Supreme courts can reject precedent if absolutely necessary. FDR's court packing plan. Ambitious attempt by FDR to stop Supreme Court invalidating New Deal, rejected by Congress's violation of separation of powers. District courts. Federal trial courts, limited jurisdiction, must follow Supreme Court and their circuit court precedents. Federal government represented by U.S. Attorney's Office. Courts of Appeals. Determines whether cases were decided correctly by the court below. Supreme Court. Final Federal Appellate Court, hears appeals from circuit courts, only hears important constitutional cases. Original jurisdiction. The jurisdiction of courts to hear a case for the first time. Trial courts assess the facts in a case and issue the first decision. Supreme Court has OJ over disputes between two states. Appellate jurisdiction. The jurisdiction of courts to hear appeals from lower trial or appellate courts. Litmus test. Make or break question when considering nominees for judiciary. Department of Justice. Federal department responsible for enforcing federal laws. Attorney General. Head of the Justice Department and the Chief Law Enforcement Officer of the United States. Solicitor General. Senior Justice Department attorney, decides what cases the government will appeal to the Supreme Court, files amicus briefs with the Supreme Court in cases the government is interested in, and represents the United States before the Supreme Court. U.S. Attorney. Government lawyer that represents the U.S. government at the district court level. Writ of certiorari. An order by the Supreme Court saying that it will hear a certain case, granted in cases that raise important constitutional questions or where circuit courts have reached different opinions on a particular issue. Rule of 4. How the Supreme Court decides whether to hear a case, requires 4 or more justices to grant certiorari. Supreme Court agrees to hear